Thank you, Mr. Chairman. Today's hearing is titled Defending Marriage, and my colleagues in the majority undoubtedly will criticize the Obama administration for deciding that Section 3 of the 1996 Defense of Marriage, or DOMA Act, is unconstitutional and cannot be defended in certain court cases. The argument that the administration has somehow acted inappropriately is a red herring, an effort by DOMA supporters to distract from the real question here, which is whether anyone should be defending this abhorrent and immoral law. The administration has decided that, at least in certain cases, it should not. The Attorney General followed the procedure that Congress established, codified at 28 U.S.C. Section 530D, for exactly this situation. And there are numerous notable examples of prior administrations that, having determined that a law is unconstitutional, have either refused to defend it or affirmatively attacked it in court. In the 1990 case of Metro Broadcasting versus FCC, for example, then Acting Solicitor General John Roberts in the Bush administration, now Chief Justice of the United States, argued that a statute providing for minority preferences in broadcast licensing was unconstitutional. Despite Supreme Court precedent applying a more permissive standard of review, he argued that strict scrutiny applied. Senate legal counsel appeared as amicus in the case defending the law, which was upheld. Clearly, there were reasonable arguments that could have been made in defense of the law. Should we now excoriate Chief Justice Roberts' efforts as purely political and worthy of punishment? His view was not vindicated in that case by the court, but may ultimately have resulted in a shift of the law, which makes it additionally clear that what the President has done here is neither unprecedented nor inappropriate. What we should be exploring in this hearing, and before the House of Representatives engages in time-consuming and costly litigation, is how anyone can justify prolonging the life of this harmful and immoral law. Speaker Boehner has announced his intent to do so, and before the House charges to DOMA's defense, we should understand the arguments the Speaker believes support his cause, and why he disagrees with the decision of the President, the Attorney General, and federal judges Joseph Toro and Stephen Reinhart, who have considered the question carefully and with the benefit of extensive legal and factual briefings. On April 4th, several of us wrote to Speaker Boehner asking for a briefing regarding his planned defense of Section 3 of DOMA. I now ask the chair of the subcommittee and full committee, the gentleman from Arizona and the gentleman from Texas, to ask the Speaker to address the committee and answer questions members on both sides of this question may have. In ruling that Section 3 of DOMA cannot survive even rational basis review, the most permissive review, Judge Toro pointed out that in 1996, when this committee and the Congress considered DOMA, we did not bother to obtain testimony from historians, economists, or specialists in family or child welfare who might have informed our decision regarding the federal interest at stake and how DOMA would affect federal programs. Now, however, the executive branch and the courts have done that job for us. At a minimum, we should consider their factual findings carefully before we insist that this law is worthy of the time and expense of a House defense. In ruling that Section 3 is unconstitutional, Judge Toro considered and rejected the justifications that Congress gave when it passed DOMA, as well as any post hoc rationalizations given to support the law. For example, he rejected the argument that Section 3 of DOMA is justified by an alleged interest in encouraging responsible procreation, finding that there is no credible support for the notion that gay and lesbian parents are not as capable as their heterosexual counterparts, and that excluding the gay and lesbian families from the federal protections of marriage does nothing to promote the stability of heterosexual parents or marriages. Equally important for the purposes of DOMA, Judge Toro found that this type of interest is properly a state, not a federal concern. The federal government has historically had no role in setting the rules for marriage, or for that matter for divorce, and therefore the federal government has no equivalent interest in regulating the underlying criteria for marriage. My colleagues who claim to be staunch defenders of states' rights should be alarmed by DOMA's unprecedented meddling in the state's affairs of marriage. DOMA denies only certain legally married couples, legally married under the laws of their states, denies to them access to federal laws that factor in marital status, including Social Security and health care programs, which secure citizens' health and well-being. The exclusion of any married couples from these programs would defy logic. That Section 3 carves out an entire class of married citizens based on sexual orientation also violates constitutional equal protection guarantees. Even under rational basis review, the law cannot survive. It certainly cannot survive more searching review, which the Attorney General and the President have concluded is the appropriate level of scrutiny for laws that discriminate against gay men and lesbians. Facing lawsuits in a jurisdiction with no statements on the question of the appropriate standard of review, Attorney General Holder applied the factors that the Supreme Court has considered when determining whether heightened review is warranted and concluded that the criteria had been met. While critics may disagree with his conclusion, it cannot credibly be argued that either he or the President have done anything remotely unprecedented and nothing that warrants calls for impeachment or reduced funding for the Department of Justice. Nor can anyone who has looked at DOMA's legislative history credibly claim that this law should enjoy the same presumption of validity as most acts of Congress. The congressional record makes perfectly clear that DOMA is intended to express moral disapproval of gay men, lesbians, and their families. Representative Henry Hyde, then chairman of this committee, for example, declared that, quote, most people do not approve of homosexual conduct, and they expressed their disapprobation through the law, close quote. During floor debate, members repeatedly voiced disapproval of homosexuality as immoral or depraved, and argued that allowing gay and lesbian couples to marry would demean and trivialize heterosexual marriage and might prove to be the, quote, final blow to the American family, close quote. This evidence of the intent of the law being to discriminate against a specific group of people based on prejudice against them or disapproval of that group, basically on pure animus, is presumptive evidence of denial of equal protection and of the need for heightened scrutiny. The administration so concluded, and that conclusion compelled the determination that the law could never survive heightened scrutiny and therefore could not be defended as to its constitutionality. In 1996, of course, gay and lesbian couples could not marry anywhere in the world. Now they can marry in 5 states and the District of Columbia. Couples like Jen and Dawn Barbaruske, who have been together for more than 20 years. In July, they will celebrate their 2nd wedding anniversary as a legally married couple in their home state of Iowa. They are raising 2 wonderful daughters, McKinley and Brianna, who are with their parents here today. Or Edie Windsor and Thea Spire, who began dating in 1965, got engaged in 1967, and finally married in 2007. Thea passed away 2 years later after the couple had loved, lived with, and cared for each other for more than 4 decades, and after, as Edie, was a constituent of mine, put it, sharing all the joys and sorrows that came their way. Far from demeaning, trivializing, or destroying the institution of marriage, these couples have embraced this time-honored tradition and the commitment and serious legal duties of marriage. Rather than defending DOMA in court, Congress should be working to repeal it. There is no redeeming moral value to a law whose sole goal and sole effect is to persecute a group of people for no reason and no benefit to anyone else. With that, I yield back the balance of my time.